Welcome, everyone. This is a conversation regarding representing military-connected victims. My name is Brian Giles. I'm counsel at Arnold & Porter in Washington, D.C. I'll be appearing today for this presentation and this discussion with two of my colleagues who have experience representing sexual assault survivors, Taryn Rath and Marissa Loya, who will join us for particular segments throughout the conversation today. So let's jump in and get started. Today, the objective of this segment is to articulate key steps in the military justice system to identify victims' rights under what's called Article 6B of the Uniform Code of Military Justice, and then to discuss some key opportunities and challenges to the application of victims' rights in the military justice system. Essentially, what we're hoping to accomplish today with this segment is to give you some basic backgrounds on representing survivors in the military justice system, to identify the laws that apply to protect those, their rights, and to give you some practical pointers in terms of what to expect if you represent a sexual assault survivor in the military. To start, I think it's useful for us to begin with a conversation on the military criminal justice system. It's important to note that the military criminal justice system, while unique, is in many ways very similar to what you might expect in any courtroom across the country. There are judges, there are prosecutors, there are defense attorneys, the Constitution applies, there's a set of rules of evidence and other generally applicable federal statutes that apply to protect the defendant's rights. To afford the government with certain opportunities to present information, as well as specific rights that we'll discuss today for the victim. That said, the military justice system is unique in certain important ways. One of the first ways that we can think of in terms of the military criminal justice system and its unique nature is the way in which a victim reports a crime. Typically on the civilian side, we know how a crime is reported. It's either reported to a member of the police force or somebody goes in and speaks with the prosecutor. Those crimes are then investigated by the prosecutors, who then make recommendations on whether or not to proceed with potential criminal charges. And then whatever jurisdiction applies, the rules governing that criminal justice process bear fruit and proceed. In the military, victims typically have three ways in which they report a crime. Now, not all victims will typically avail themselves of these resources because of the uniqueness of victims who are in uniform. But there is something called restricted reporting and unrestricted reporting. And for those in the military, restricted reporting is an avenue by which a victim can report to certain protected recipients, meaning information is protected from further disclosure. And those in the military, active duty soldiers, sailors, and Marines may avail themselves of this opportunity if the issues have not been raised to their chain of command or otherwise to third parties. And it provides victims with an opportunity and a space, typically after an assault, to be able to think through the consequences of moving forward and hopefully to make an informed judgment about how they want to proceed and what's best for them. Another avenue of reporting is called unrestricted reporting. That can happen initially by a report to law enforcement, to either a civilian or military law enforcement agency. It can also happen by reporting through the chain of command or to other third parties who have an obligation to report criminal activity. And then finally, one other important avenue by which reports take place is through civilian law enforcement. It is not uncommon, as we'll discuss, for victims of sexual assault to not actually be soldiers, sailors, and Marines, but to be either family members or otherwise civilians who have been allegedly assaulted by a member in uniform. Once a crime is reported, the investigation that takes place with respect to that crime can occur in multiple different ways. The most typical and common way is through the military investigative units, the Office of Special Services, the National Crime, the Navy Criminal Investigative Service, or CID, which is the Army's investigative unit. Each of the military branches with the Navy and the Marine Corps combined has a law enforcement agency whose obligations are to investigate sexual assaults and are actually required by law to investigate any allegation of sexual assault made against an active duty soldier, sailor, or Marine. There are also investigations that can take place by local law enforcement agencies in the case of civilians who bring their cases to local law enforcement. It is not uncommon to see that at least initial local law enforcement is involved in investigations. And there are also potentially the involvement in foreign jurisdiction of foreign law enforcement for soldiers, sailors, and Marines who are outside of the United States and who otherwise are alleged to have engaged in illegal activity, particularly specifically sexual assault. The investigation proceeds as an investigation would, you might expect an investigation to proceed. There are often interviews, there are often pretext calls between the victim and the target of the investigation. There can be forensic information, the pulling of emails, the identification of social media, and other law enforcement functions that take place. OSI, NCIS, and CID OSI and CID have typically uniform investigators, whereas NCIS is typically their civilian federal investigators. But the results in terms of what they do are the same. They conduct the basic investigation, and they will provide their findings to a set of attorneys who will be advising the prosecuting authority, which we will discuss. One side note with respect to the investigation is that the rules of court-martial provide that a victim be notified of the ability to request a civilian prosecution instead of a military prosecution. Setting aside whether that's something to recommend, which is something we can talk about perhaps in another session, it's important to recognize that the victim has a right to be informed of and be heard on a request to proceed in a civilian criminal justice system as opposed to the military. Their request does not have to be honored, but it must be heard. Following the investigation, there is something called the convening authority. And this is where the current military justice system significantly diverges from the civilian justice system. In the civilian justice system, you would expect an independent district attorney, sometimes elected, sometimes appointed, sometimes senior, sometimes junior, depending on the situation, will have authority to decide whether or not to proceed with charges, either through the convening of a grand jury in certain jurisdictions, including in federal jurisdictions, or through some other indictment measure and finding a probable cause, depending on the nature of the jurisdiction. But ultimately, the initial decision on whether or not to move forward and charge an individual is a decision made by an attorney in a prosecutorial capacity. That is not the case in the military. In the military, the convening authority, an individual who sits within the target or defendant or accused, depending on how you want to refer to them, sits in their chain of command. And there are a limited number of convening authorities. For Article 120 sexual assaults, you're typically talking a general or an admiral who is making that decision. The convening authority is a military officer, not a lawyer, and they're typically not lawyers. They have many responsibilities beyond the administration of justice. The convening authority is, however, advised by attorneys who represent the convening authority and provide information and legal advice with respect to a wide variety of matters, one of which is whether or not to bring charges, or what we call prefer charges. And what preferral means in this context is simply the extension of a charge. It's like an indictment. It's like an initial charging instrument. The convening authority makes that preferral decision based on the advice of his or her attorneys, which triggers a preliminary hearing process called the Article 32 hearing. Article 32 is an article in the Uniform Code of Military Justice. It has evolved over time in terms of what it entails, but currently it's basically an on the papers probable cause determination that is not designed to afford the defendant access to additional discovery, but is designed to ensure a slight gatekeeping function for charges before they go to a court martial. And Article 32 is handled by someone called a preliminary hearing officer. They function much in the same way as a military judge, but they do not have to be a military judge. They are frequently attorneys who have experience handling preliminary hearings or trained to do so, but they are not typically military judges. Their obligation is to provide a report and recommendation of the findings of fact and probable cause to the convening authority for their review. Now, the convening authority is not bound by the Article 32 preliminary hearing officer's determination. It is simply designed at this stage, in the current rules that we operate, the preliminary hearing officer's opinion is taken into account. If the convening authority receives advice from his counsel or her counsel that there is adequate probable cause to proceed with the trial, then the convening authority convenes a court martial. In the military, there are no active courts. If you think about going down the street, your local courthouse to file a complaint, to seek an injunction, to file small claims, those are the types of active courts that exist and are going every day of the year, typically in very, very busy urban jurisdictions and frequently elsewhere in other jurisdictions. Those busy courtrooms do not have a parallel or a similar experience in the military. Instead, the convening authority convenes a court martial and appoints a military judge and an initial set of counsel for defense and the prosecutors, and thus begins the trial system and the trial process that we call courts martial. We'll talk a little bit more in another segment around what to expect and experience in a court martial, but at the end of the day, court martials contain juries. They have rules of evidence and a witness stand, the same types of adversarial cross-examination and competition between the prosecutor and defense counsel that you see in civilian jurisdictions applies in the court martial process. And so in many ways, the rule of law, the case law, the binding nature of case law, all of those things exist in the military justice system. So in many ways, even if you don't have experience representing or being in the military, you can certainly learn enough about the rules and have access to the information to ensure that you're successful. And finally, and we'll talk again in a separate segment about this, there's the appellate court system. There are appellate courts that exist at an intermediate level, criminal courts of appeals for each of the military branches that hear appeals that are then subsequently, can be subsequently appealed to the Court of Appeals of the Armed Forces, or the CAF, which is essentially a circuit level federal court whose decisions are reviewed and referred to the United States Supreme Court. So I wanted to turn next to the question of victims' rights and how did we get here? I'll assume for purposes of this discussion a basic familiarity with the concept of victims' rights and the importance of victims' legal counsel to the experience of the survivor and of the survivor's efforts to move from victim to survivor and obtain at least some of justice. In the military, the history of victims' rights really begins in 2013, when the Air Force developed, in consultation with NCVLI and others, a training program and ultimately initiative to detail or appoint victims' legal counsel to active duty airmen who were the alleged victims of sexual assault. It was the first program in the military and really was state of the art at the time. Now, the issue with that program in 2013 wasn't that it wasn't needed or that there wasn't a lot of excellent training or outstanding resources provided to those attorneys. The challenge really was ambiguity in the law regarding the opportunity of victims' legal counsel to be heard and a lack of specificity as to the rights of victims in the military. So importantly, in 2013, there was a decision called LRM versus Kastenberg. This was a decision that was by writ to the Court of Appeals of the Armed Forces. So the highest level court within the military justice system short of the United States Supreme Court. And in the LRM versus Kastenberg, the question that arose was whether or not a victim had a right to be heard through counsel when disputing and arguing issues related to military rules of evidence governing rape shield protections and the psychotherapy privilege. And initially, the court determined that any right that the victim would have could be exercised through consultation with the prosecutors. Ultimately, in LRM versus Kastenberg, the Court of Appeals for the Armed Forces disagreed with the lower court and determined that a victim had an independent right to be heard through counsel in writing and orally regarding rights that impacted directly the victim, and specifically the rights to be protected from invasion of psychotherapists and piercing of the psychotherapist privilege, or issues related to military rule of evidence 412, the rape shield law. Around the same time as LRM Kastenberg, the federal courts and the federal, really the legislature, were considering enhancements to the military justice system. And one of those enhancements was the specific articulation of rights akin to the Crime Victims' Rights Acts and rights that we see in many state constitutions and state bills to protect crime victims. Those included enhancements called Article 6B, which is a series of rights that I will review today that provide specific federal statutory protections for victims to be heard, to be reasonably protected, to be able to confer with prosecutors, among a myriad of other rights that are now codified under federal law. Subsequent enhancements to Article 6B included additional specific appellate rights, the right to be present at trial and at preliminary hearings, the right to refuse to be interviewed or deposed by the prosecutor or defense counsel, a right that prior to enactment of this statute was routinely ignored, with victims routinely being either coerced or encouraged to speak to defense counsel prior to trial. And then some additional therapy privilege protections that will be addressed separately that really enhanced the ability of victims to prevent not just the defendant, but the court from piercing the important psychotherapy privilege protections that exist for sexual assault survivors. So who is a victim? A victim in the context of this work is an individual who has suffered direct physical, emotional, or pecuniary harm. And that includes active duty soldiers, sailors, and Marine, military personnel and their family, as well as civilian victims. So within the context of this system that I'm describing today, civilian victims have the same rights as active duty victims in terms of the rights to be heard and to have counsel. Now, there are some differences in the provision of that counsel, which we'll discuss, but in terms of the distinction between civilian and military, there really is no difference beyond the privacy protections that we will address later, and the diminished privacy expectations that active duty soldiers, sailors, and Marines experience in light of their unique role in the military. So right and access to counsel is really where it begins. The access to counsel and the ability to have counsel, be the voice for a survivor, is critical to the victim's experience. It's essential for the victim to be able to not just be informed of the proceedings, not just to be told why, but to actually have power given to them by their attorney who can go into court and advocate on their behalf. And that's really what the value is of the Victims Legal Counsel program. Its success is not defined by a guilt or innocence plea, but by the empowerment that the victim can bring to the survivor throughout that process. So what are the rights and who has access to counsel? So as I mentioned, all defined victims have a right to counsel. Active duty, DOD, and military dependents actually have access to free military detailed counsel, meaning uniformed attorneys who represent them free of charge. That access to counsel currently exists for alleged victims of sexual assaults. There has also been a recent expansion of that to the domestic violence space, and there continues to be various branches with various other ways in which they might expand those services. For example, to all sexual assault abuse survivors, regardless of whether or not they are or their families are military dependents. The right to counsel that exists is triggered at the time the victim seeks assistance from either a sexual assault response coordinator, a victim advocate, a military criminal investigator, a victim or witness, liaison trial counsel, which is the words we use for prosecutor in the military, a healthcare provider, or any other personnel designated by the Secretary. So importantly, the right to counsel does not require an indictment to trigger that right. And in many ways, soldiers, sailors, and Marines in particular, who are interested in understanding how reporting will impact them professionally and with their colleagues, with their fellow soldiers, or fellow Marines, or fellow sailors, that type of practical advice is critical, I think, for those individuals, and it does not require an indictment. It triggers at any one of these events, including the initial report, including having counsel available to assist and advise during an initial report. And the assistance is available regardless of whether or not an individual elects restricted or unrestricted. And that's important. One of the rationales and reasons for unrestricted reporting was to give the victim an opportunity to have space outside of that initial trauma-filled moment to be able to make a decision on what's best for them and whether or not to report. But having access to counsel during that process and that consideration that a victim is undertaking, hugely impactful and a really significant enhancement in the law to provide for that. And as I mentioned, the expansion of counsel to other offenses, including domestic violence, continues to be an ongoing consideration and a balance between the desire to expand these services to as many victims as possible across different multiple crime categories, but also having enough detailed military counsel to be able to adequately spend the time and have the energy to effectively and aggressively represent their. So who are military detailed counsel? You'll see three here, three heroes of mine, individuals who represented victims in the military. You can see in the upper left-hand corner, the number of SVCs has largely stayed stagnant over the last several years, despite a significant increase in the number of reports of sexual assaults in the military. So there is a relatively small in terms of the number of attorneys that are representing these victims, but a huge organization collectively. If you think of this organization holistically, the largest victims' rights direct legal services organization in the world, with over 150 attorneys representing crime victims. And they represent active duty soldiers, sailors, and Marines. They do not represent civilians unless those civilians are card-carrying members, meaning they are family of their DOD or military dependents. So there is a significant segment of the population that does not receive military detail victims legal counsel. And it's one of the reasons that we encourage lawyers across the country, civilian lawyers across the country, to take these cases, because we know from the data and we know from our own anecdotal interactions with Victims Legal Counsel, military detailed and civilian, that there are civilian lawyers that are needed. And they're needed in these cases because there are no other lawyers to represent them. And in addition to that, even with those active duty soldiers, sailors, and Marines who have provided military detailed counsel, there is a significant segment of the survivor population who does not trust the military to actively and effectively advocate for them. And for those cases where making a report is contingent upon having the trust of the lawyer, there are opportunities for civilians to fill that space in those specific circumstances. For example, where a victim would not come forward unless they were comfortable that there was a civilian outside of the chain of command and candidly outside of the branch in which they served to represent them before they would be willing to move forward with an investigation and all that it entails.